Welcome to NIPT's Decisions on the Go, using AI for over a decade to help you listen to New York State Court of Appeals decisions on the go. After the podcast, visit www.nipt.com/law to read the full decision.
People v. Samuel Shaw, decided February 19, 2026. Holligan, J. The defendant was convicted of 2 counts of murder in the first degree, 2 counts of murder in the second degree, attempted murder in the second degree, assault in the first degree, and 3 counts of criminal possession of a weapon in the second degree, stemming from a shooting that left 2 people dead and another paralyzed. On appeal, he argues that a gun discovered in an apartment where he stayed overnight should have been suppressed because he was arrested in violation of Payton v. New York, and that the subsequent search of the apartment was based on consent from the tenant that was neither voluntary nor attenuated from the illegal arrest. Although there is more than sufficient record support for the appellate division's conclusion that the defendant was coerced to leave the apartment in violation of Payton, the appellate division applied the wrong legal standard to determine whether the tenant's consent was voluntary. We therefore remit the matter to the appellate division for application of the correct legal standard. Because we conclude that any error would be harmless in relation to all counts except for count 9, charging the defendant with criminal possession of a weapon in the second degree, the appellate division need consider only that count on remittal. 1. The evidence at trial established that in June 2018, defendant Samuel Shaw shot and killed 2 people and paralyzed another in a parking lot in the city of Rochester. 2 eyewitnesses, including the surviving victim, identified the defendant as the shooter the next day. Those identifications were supported by forensic evidence. The police recovered shell casings, projectiles, and a magazine ejected from a handgun from the scene of the shooting. They determined that the casings and projectiles had been fired from the same 9mm handgun, and the magazine had the defendant's palm print on it. Following the defendant's arrest, police discovered a 9mm handgun inside a toilet tank located in an apartment where the defendant had stayed overnight. As a result of a search warrant executed at a different address, the police also found an empty box for a 9mm handgun bearing the same serial number as the gun discovered at the apartment and identified the defendant's fingerprints on the box. This appeal concerns the legality of the defendant's arrest and subsequent search of the apartment. On July 21, 2018, 15 members of the Monroe County SWAT team and additional uniformed officers arrived at the apartment in an armored vehicle called a Bearcat. The SWAT team members wore body armor and camouflage tactical clothing and carried assault rifles. The defendant did not live in the apartment, but had been there for approximately 18 hours and stayed overnight the prior evening. An officer admitted that the police chose not to obtain an arrest warrant for the defendant because they wanted to interview him before his right to counsel attached. A police investigator testified that upon seeing the defendant through the apartment window, he shouted at him to, "Come on out, house is surrounded, come out empty-handed and come out with your hands up." The defendant then shooed the tenant of the apartment and her 16-year-old cousin into the laundry room and exited the building, at which point he was taken into custody. Officers then entered the apartment and ordered the tenant and her cousin to come out with their hands up and lie face down with guns to them. The tenant testified that she was scared. She and her cousin were handcuffed, and the police separated them and put the tenant into the back of a police patrol car where she could not see her cousin and remained for approximately 5 to 7 minutes. An officer obtained the tenant's consent to search. While the record is unclear as to whether verbal consent was provided when the tenant was still handcuffed, an officer removed her handcuffs before she signed a written consent to search form. The tenant testified that she was not intimidated throughout this encounter and that police neither promised anything in exchange for her consent nor threatened her. After the tenant signed the consent form, officers searched the apartment and found a gun inside the toilet tank in the bathroom. Before trial, the defendant moved to suppress the gun, arguing that his arrest violated Payton v. New York and that the tenant's consent to search the apartment was neither voluntary nor sufficiently attenuated from the Payton violation. The people responded that there was no Payton violation because the defendant had been taken into custody outside the apartment and that he had no reasonable expectation of privacy in the apartment and thus lacked standing to challenge the search. The trial court denied the suppression motion, holding that the defendant's arrest did not implicate Payton because he was arrested outside the apartment. The court further held that the defendant lacked standing to challenge the search, and in any event, the tenant had voluntarily consented to the search. The case proceeded to trial, and the defendant was convicted of all charges and sentenced to life in prison without the possibility of parole. On appeal, the appellate division held that the defendant's arrest violated Payton, but that suppression of the gun was not required. With respect to the arrest, the court found that the number of officers, their attire in tactical SWAT gear, and their manner of entry constitute coercive circumstances, suggesting that defendant was submitting to authority by leaving the apartment, rather than doing so voluntarily. The court further concluded that despite the Payton violation, the tenant's consent to search the apartment was voluntarily given and attenuated any initial illegality. One justice dissented, concluding that the consent to search was neither voluntary nor sufficiently attenuated, but would have found the error harmless in relation to the defendant's convictions for murder in the first degree, attempted murder in the second degree, assault in the first degree, and 2 of the 3 counts of criminal possession of a weapon in the second degree. The dissenting justice granted the defendant leave to appeal to this court. 2A. Initially, we reject the people's argument that the defendant failed to preserve his contention that his arrest violated Payton. In his suppression motion, the defendant argued that officers from the Rochester Police Department ordered the defendant to exit his temporary domicile and arrested him, that the arrest violated Payton, and that the firearm recovered from the apartment was obtained as the direct and unattenuated result of an unlawful police arrest and should be suppressed. Defense counsel made similar points at the suppression hearing. These arguments were sufficient to alert the trial court to the nature of the defendant's claim and preserve the argument for review. We also conclude that the defendant has standing to raise this challenge because, as an overnight guest, he had a reasonable expectation of privacy in the apartment. See Minnesota v. Olson. B. In Payton v. New York, the U.S. Supreme Court held that, absent exigent circumstances, the Fourth Amendment prohibits the police from making a warrantless and non-consensual entry into a suspect's home in order to make a routine felony arrest. This rule is grounded in the overriding respect for the sanctity of the home that has been embedded in our traditions since the origins of the Republic. Indeed, the zone of privacy protected by the Fourth Amendment is at its apex when bounded by the unambiguous physical dimensions of an individual's home, a zone that finds its roots in clear and specific constitutional terms. The right of the people to be secure in their houses shall not be violated. The defendant contends that even though he was taken into custody outside the apartment, his arrest nonetheless violated his rights conferred by the Fourth Amendment and Article 1, Section 12 of the New York Constitution, under a theory of constructive entry. Although Payton does not squarely address these circumstances, it makes clear that the home lies at the very core of the Fourth Amendment. See also People v. Minley. The evil to which the Payton rule is addressed is the unsupervised invasion of a citizen's privacy in his own home. When officers subject someone to a display of authority that induces them to exit the home under coercion, the sanctity of the home has been invaded to the same extent as if the officers had physically entered. Such a show of force violates Payton and renders an arrest unlawful under both the Fourth Amendment and the New York Constitution, just as it would be if the arrest occurred within the confines of the home itself. That conclusion accords with the prevailing view of other courts that have considered the question. To give one example, the Ninth Circuit held that a defendant was arrested inside his residence for purposes of Payton when police surrounded his trailer with their guns drawn and ordered him to come outside, and that subsequent consent by the defendant and his wife to search their trailer was therefore not voluntary. United States v. Alazawi. Other courts have found Payton violations in similar circumstances. See United States v. Saari. Defendant's warrantless arrest was accomplished while he was in his home, and thus violated Payton, where officers surrounded the house, flooded it with spotlights, and summoned the defendant with a bullhorn. United States v. Maez. Police surrounded the defendant's trailer and, with guns pointed at the home, asked him and his family to come out. United States Nora. Defendant was arrested inside his home for purposes of the Payton rule, where police surrounded the defendant's house and ordered him to come out at gunpoint. Sharar v. Felsing. SWAT teams surrounded the defendant's home with guns pointed at the windows and ordered the defendant to leave the house. Maloney v. County of Nassau, EDNY 2007, citing ample authority, recognizing a Payton violation in the absence of a warrantless physical intrusion into the home. CF, United States v. Allen, arrest violated Payton where officers knocked on defendant's door and told him he would need to come down to the police station to be processed. State v. Holman, a person's home can be invaded to the same extent when the police remain outside the house and call a person to the door as when the police physically enter the household itself. State v. Dahl, permitting the police without a warrant to seize a person inside his house by ordering that person to emerge from his house would be inconsistent with Payton's well-established constitutional principle. Nor do we share the dissent's view that courts are meaningfully divided over whether Payton prohibits police from compelling a defendant to leave their home. To be sure, several federal circuit courts have held that warrantless arrests do not violate Payton, where officers simply knock on a defendant's door and ask them to come outside. But such knock-and-talk encounters are distinct from the use of coercive tactics to force a defendant out of the home. See United States v. Thomas, distinguishing a consensual knock-and-talk visit from an encounter where police, while not entering the house, deploy overbearing tactics that essentially force the individual out of the home. Knight v. Jacobson, acknowledging some courts have held that when the suspect leaves his home because of coercive tactics by the police, the arrest is illegal, but finding no such tactics in this case. Both United States v. Berkowitz and United States v. Carrion involved warrantless arrests at the doorway of a defendant's home after police knocked on the defendant's door and the defendant voluntarily opened it, rather than allegations of constructive entry. Our conclusion is also fully consistent with this court's precedent. We have permitted warrantless arrests where a defendant voluntarily comes to the doorway or exits their home, but those cases did not involve coercive police conduct. For example, People v. Garvin involved a simple knock at the door and included no allegation of coercion. We expressly noted that we were bound by the appellate division's finding that the defendant voluntarily emerged from the home and effectively reserved the question presented here by flagging that defendant does not ask us to apply the constructive entry rule in this case. The cases Garvin cites similarly involved non-coercive police tactics, citing People v. Spencer, People v. Reynoso, People v. Rowe, and Minley. And the warrantless arrests in those cases did not run afoul of Payton for that reason. Nothing in these cases decides or even directly bears on the question before us today. As for the protection conferred by the state constitution, we explained in People v. Harris that in light of the interplay between the state's right to counsel rules and search and seizure provisions, the state constitution provides even more robust protections against patent violations than the Fourth Amendment. Accordingly, we conclude that the state constitution encompasses a theory of constructive entry as well. C. Although some cases may present a close question as to the line between voluntariness and coercion, we have no trouble upholding the appellate division's conclusion that a patent violation occurred in this case. Because the appellate division's determination that the defendant was coerced to leave the apartment presents a mixed question of law and fact, see Garvin, our review is limited to ascertaining whether there is record support for the court's determination that the defendant's exit from the residence was a mere submission to a claim of lawful authority rather than a voluntary exit. See also Spencer. We conclude that the record amply supports the appellate division's determination that the defendant was coerced out of the apartment. The building was surrounded by more than a dozen SWAT team officers dressed in tactical gear and carrying assault rifles. There was an armored SWAT vehicle on the premises. An officer, upon seeing the defendant in the window, ordered him to come out empty-handed and come out with your hands up, and told him that the building was surrounded. In the face of this overwhelming show of authority by police, no reasonable person would have felt free to ignore the officer's command to exit the home. We therefore conclude the defendant's arrest was unlawful under both the Fourth Amendment and Article 1, Section 12 of the New York Constitution. 3. A. Notwithstanding its conclusion that the defendant's arrest violated Payton, the appellate division found that suppression of the gun discovered inside the apartment was not necessary because a tenant's valid consent can attenuate any initial illegality in the constructive entry, and here, the tenant's consent was voluntarily given. As we explain, see Infra Point 3b, the appellate division erred by failing to distinguish between voluntariness and attenuation and by applying the wrong factors in assessing the voluntariness of the tenant's consent. A threshold question, though, is whether attenuation analysis applies at all where a third party, rather than a defendant, provides consent to search. We assumed as much in matter of Leroy M. Noting the party's stipulation that a third party's consent to search a home was voluntary, the court proceeded to analyze whether the consent was sufficiently attenuated from the prior illegal entry into the home and concluded it was. Although we did not explicitly hold that attenuation analysis may apply to a third party, there would have been no reason to examine the question if the court thought otherwise. See also People v. Banks, suppressing evidence discovered following a traffic stop because a third party's consent was not acquired by means sufficiently distinguishable from the taint of illegal detention. That understanding comports with the purposes of the exclusionary rule, to deter lawless conduct by police officers, and to close the doors of the courts to any use of evidence unconstitutionally obtained. Brown v. Illinois, quoting Wong Sun v. United States. Permitting a police officer to use evidence discovered after entering a home in violation of Payton, so long as they subsequently obtain consent from a third party, could incentivize officers to violate Payton without repercussion anytime there are two people in a home by simply asking for consent from the third party. We thus decline to create a categorical rule, as the dissent would, that a defendant's unlawful arrest can never taint the consent of a third party. Our conclusion is consistent with the decisions of numerous federal circuit courts and state high courts that have considered whether a third party's consent was sufficiently attenuated from prior illegality when ruling on a suppression motion. For example, in United States v. Oaxaca, the Ninth Circuit explained that consent by a defendant or a third party is tainted where the evidence indicates that it stemmed from the prior illegal government action. Similarly, in State v. Lane, the Supreme Court of Iowa analyzed in painstaking detail whether a third party's voluntary consent was obtained by exploitation of the illegal entry and arrest of the defendant, ultimately concluding that the consent was sufficiently attenuated from this prior illegality. See also United States v. Maes, United States v. Valentine, United States Vega, People v. Boyer, State v. Miller, Millam v. Commonwealth. We see no reason to deviate from this prevailing view. Rather than address third-party consent head-on, the dissent contends that New York v. Harris bars application of the exclusionary rule here, relying on a passage which holds that attenuation analysis should not be employed where evidence is obtained outside of a defendant's home after an arrest made in the home in violation of Payton. This argument was not presented to the court, and the People's Brief does not cite Harris. In any event, Harris does not preclude application of attenuation here. The Supreme Court emphasized in Harris the distinction between a statement made outside the home, at the station house, and evidence found or statements taken inside the home, Harris. The station house statement was not subject to exclusion, but the principal incentive to obey Payton still obtains. The police know that a warrantless entry will lead to the suppression of any evidence found or statement taken inside the home. People v. Jones, which declined to suppress identifications secured through a lineup conducted 5 hours after an unlawful entry into a home, presumably at the station house, tracks that approach. Here, by comparison, the evidence subject to exclusion, the gun, was discovered inside the home, and that is precisely what Payton protects. Moreover, the Supreme Court's determination that attenuation analysis was unnecessary in Harris does not resolve whether attenuation is appropriate when a Payton violation occurs through constructive entry, which necessarily involves coercing a defendant to exit the home. Under those circumstances, evidence or consent obtained just outside the home and immediately following the Payton violation could be an exploitation of the illegal constructive entry and resulting exit. If Payton encompasses constructive entry, as we hold it does, it seems unlikely that Harris, a case that did not involve constructive entry, would somehow preclude relief on that basis. Nor do we see anything in Harris that requires us to treat consent obtained from a third party differently than consent from a defendant. Attenuation analysis is also required under the state constitution. As we explained on remand from the Supreme Court in Harris, the Supreme Court's ruling regarding the scope of the exclusionary rule under federal law is not adequate to protect New York citizens from Payton violations because of our right to counsel rule. In contrast to federal law, under New York law, police are prohibited from questioning a suspect after an arrest pursuant to a warrant unless counsel is present, and therefore have every reason to violate Payton because doing so enables them to circumvent the accused's indelible right to counsel. That is exactly what happened here. Allowing police to coerce a defendant out of the home in violation of Payton, and then, in the absence of counsel, seek consent to search the home could surely put the police in a better position than they would have been in if no illegality had transpired. Jones. That the consent was provided by a third party here does not obviate these concerns. Thus, under these circumstances, we believe an additional layer of protection against unlawful police entry into the home in the form of attenuation analysis is appropriate. Providing this safeguard under the state constitution is, as then-Judge Kaye once said, a perfectly respectable and legitimate thing to do. People v. Scott. As has been true for decades, our objective has been the protection of fundamental rights, consistent with our Constitution, our precedents, and own best human judgments in applying them. B. Here, the Appellate Division applied an incorrect legal standard in considering the validity of the tenant's consent. People v. Gonzalez sets forth the factors that should be considered in determining whether the consent was voluntary. Those include whether the consenter is in custody or under arrest, The circumstances surrounding the custody or arrest, including whether the person was confronted by a large number of police agents, whether the person was handcuffed, the background of the consenter, including their age and prior experience with police, whether the consenter has been evasive or uncooperative with the law enforcement authorities, and whether the person was advised of their right to refuse to consent. The Appellate Division instead recited and applied the factors set forth in People v. Borges, which go to whether voluntary consent was attenuated from an illegal arrest, not whether the consent itself was voluntary. The Appellate Division erred in applying the attenuation factors from Borges rather than the voluntariness factors set forth in Gonzalez in determining that the tenant's consent was voluntary. Voluntariness and attenuation, though related, are separate inquiries that turn on distinct considerations. The Appellate Division should have the opportunity to assess the voluntariness of the defendant's consent under the correct legal standard in the first instance. C. As the people concede, suppression of the gun would require dismissal of Count 9 of the indictment. That count of criminal possession of a weapon in the second degree stems from the defendant's possession of the gun that was discovered at the apartment on the date of his arrest, and there was no other evidence presented to support this charge. Any potential error regarding suppression of the gun would be harmless, however, as to all remaining counts of the indictment. Those counts for murder in the first degree, attempted murder in the second degree, assault in the first degree, and criminal possession of a weapon in the second degree all stem from the shooting incident. The evidence of the defendant's guilt, including 2 eyewitness identifications, a magazine from a handgun with the defendant's palm print on it, shell casings and projectiles from a 9mm handgun, and an empty box for a 9mm handgun with the defendant's fingerprints on it, was overwhelming with respect to those charges. We conclude that there is no reasonable possibility that any potential error might have contributed to defendant's convictions on those counts, People v. Crimmins. We therefore remit to the Appellate Division to consider whether the gun should be suppressed under the correct legal standard for determining the validity of the tenant's consent with respect to Count 9 only. Accordingly, the order of the Appellate Division should be modified by remitting the case to the Appellate Division for further proceedings in accordance with this opinion and, as so modified, affirmed. Order modified by remitting to the Appellate Division, 4th Department, for further proceedings in accordance with the opinion herein and, as so modified, affirmed. Opinion by Judge Holligan. Chief Judge Wilson and Judges Rivera and Troutman concur. Judge Singas dissents in part and votes to affirm in an opinion, in which Judges Garcia and Canataro concur. Decided February 19th, 2026.
Welcome to NYPTI's Decisions on the Go, using AI for over a decade to help you listen to New York State Court of Appeals decisions on the go. After the podcast, visit www.nypti.com/law to read the full decision.